Thanks so much for everyone who's tuning in to watch this. I have a really special guest with me today, and we're going to discuss a very important topic about workplace harassment and constructive dismissal issues. Sarah Miller obtained her bachelor's degree and law degree from the University of Calgary. After graduation, she articled at a global law firm in Calgary before joining JSS Barristers in 2019. She has previously worked in criminal prosecutions and in-house with both a public institution and a large energy company. Sarah's passions are community and health, sitting on the board of the Alberta Institute for Wildlife Conservation. In her spare time, she enjoys amateur gardening, running, and hot yoga. She is a fourth-generation rural Albertan. Sarah has successfully represented clients in provincial court and Queen's Bench throughout Southern Alberta. She has civil litigation experience with a particular interest in employment, shareholder, environmental, and regulatory disputes. During law school, Sarah participated in the Alberta Court of Appeal moot and the Western McIntyre Cup moot with much success. During all 3 years of law school, Sarah was a caseworker with student legal assistance, gaining litigation experience in criminal, civil, and family matters. She also practiced poverty law and wrongful convictions in 2 clinical courses. As a student, Sarah volunteered her time as a program coordinator with Pro Bono Students Canada and as a student representative for the Society of Law Students and the Calgary Bar Association. And I'm so excited that you're here with me this evening to discuss workplace harassment and constructive dismissal. And you're the expert. I'm so excited to learn from you. And thank you so much for joining me.
Thanks, Tegan. Yeah, I'm excited to talk about it too. It's really what I do all day, every day now. So it's nice to be able to talk to somebody without, having them be subject to all of these issues. So very nice to be here.
I can imagine it's, I mean, I don't want to speak for you, but is this something that you have found during COVID to have increased even more, these levels of issues?
Yeah, absolutely. I mean, we've seen both happen. On one side, we're seeing a little bit of an alleviation because people are moving to the work from home model, and so they have some insulation between them and people who are responding adversely to them, whether by bullying or harassment or those types of things. But then at the same time, we have in certain environments, it's really amping up because everybody is under so much more stress these days. Everybody is so much more emotional about all sorts of things. And so it's really coming out in where we spend our time, which is in our workforces. So we're seeing both, but certainly like almost everything over the past 18 months, bad behaviors are getting worse, almost kind of across the board.
Yeah, absolutely. Absolutely. I think this is a great time actually to be discussing issues such as workplace harassment. And Sarah, this is, in your experience, how do these things play themselves out? From what you see, what types of people engage in this harassing behavior, and what kinds of people are usually targets? How does the situation typically begin in your experience?
Yeah, so I would say the majority, from my experience, right, which is only one person and a limited number of years at the bar, but almost overwhelmingly, it's women who are the targets of these types of behaviors. You can point to a number of social science studies that indicate that would support that kind of dynamic, right? That a woman is going to be interpreted differently in the workforce, and she's going to be subject to different adverse treatment in the workforce. And so that it's sad in 2021 that like the first place I have to go with this is gender at this point, but certainly that seems to be one of them. And frankly, any protected ground under the typical human rights legislation is almost certainly going to be the next one, right? So gender, whether that's non-cisgender or being female, that's the main one that I see. There's also racial issues in the workforce, and then religious discrimination, those types of things. So If it's a protected ground under human rights legislation, it's likely to be, a trigger, I suppose, for the type of people who are engaging in this kind of behavior.
Now, do you ever see things like that are outside of that, like say female on female workplace harassment and things of that sort?
Yeah, absolutely. I mean, depending on the work environment, right? So in certain work environments, I think women have figured out ways to work collaboratively and together, but you see it a lot in what we have here in Calgary is a lot of engineering, geoscience, that type of oil and gas environment. Those environments traditionally were dominated by men. So we have boomer women in that age group who have developed their whole identity around being one of the very few women or the only woman in the workforce. And then they tend to, what we see is that they tend to then, women coming up in the workforce, they think they treat them adversely or more harshly and have these really visceral type of bullying behaviors that develop out of that. And whether it's, and there's a lot of social science around this as well. We're kind of outside the legal analysis, but it might be, kind of motivated by either jealousy or trying to protect their own bubble or what have you. So we definitely see that woman on woman as you described, but usually it's also a generational gap in those cases of some nature. It's not always the boomer generation against the millennial generation. I don't want to perpetuate that kind of adverse relationship, but it's usually at least a 10-year gap sort of in age to see, and 10 years in seniority to see that kind of dynamic playing out between women, ordinarily from my experience.
That's what I've seen and heard as well, actually. And what are some examples of what is workplace harassment? Exactly. How do you define that?
Yeah, so that is an incredibly challenging thing to define. The courts really struggle with that as far as trying to determine whether or not there was workplace harassment. Ordinarily, we see, for example, in human rights, we see harassment as when you suffer an adverse consequence based on your protected characteristics. So if you are suffering some sort of adverse consequence and the behavior is causing that, right? So that's usually what harassment looks like. As I say, the courts have a really challenging time trying to draw a line. This is harassment, this isn't harassment, those types of things. Like when it's legislated, such as in human rights law, it's often, or occupational health and safety law, it's usually distinguished by, what's reasonable for management or employers to kind of do and engage with, and what is outside of that usual management kind of responsibility or discipline, those types of things, right? So you discipline an employee over and over for being late. That's probably not harassment unless the employee can show, well, everybody else is, just as often late as I am, and for whatever reason you're targeting me. Right. So it is a very nuanced situation. In Alberta, we have the Occupational Health and Safety Act. In 2018, that act was revised to include harassment, and there hasn't really been a lot coming out of that revision. It's obviously something employers have now had to think about. Are they meeting their Occupational Health and Safety Act requirements to prevent workplace harassment? But there hasn't been a lot of guidance since those revisions in 2018 here in our province.
Okay, and so say somebody has identified for sure, they're a great employee, they cross all their T's, they dot their I's, their performance is awesome, they're always on time, and they're being scapegoated. They're being targeted, they're being scapegoated, and not only by one person, but sort of in a mobbing type of situation at a workplace. What should that person start to do, maybe aside from getting out, but like what can that person do when it's in a situation like that?
Yeah, so I mean, this is a really challenge. We get a lot of employees who come to us with these kind of issues, right? They feel like they've been targeted in some way, such as scapegoating or whether it's mobbing or not, somebody is targeting them and harassing them. The challenging thing is, well, how do you manage that? And it really depends on what kind of organization you're in. If you're in a really large organization with a separate HR department that's not part of this and is not, an instrument of the people targeting you in your group, maybe reaching out to the HR group and figuring this out with them might work. Also, if it's a big organization, maybe you go high enough up the chain and you can request to be moved into a different unit, different workforce, that kind of thing. Unfortunately, not all of us have the benefit in those cases to be able to shift around in a large organization, or to go to some sort of external type of body outside of the toxic environment to get remedy. So often what we see is, in these circumstances, especially what you've just described in mobbing circumstances, is a small company or a small environment, at least working environment, where there's not any opportunity to get out and maintain employment. So in those circumstances, I always recommend everybody should take notes and record, like via, not necessarily by hand, you can type it, but record what's happened kind of on a daily basis. So keep a diary of sorts with respect to what's happening to you. Memory is really fallible. You'll forget things, you'll forget dates. If it gets to a point where litigation is necessary, or as it results, you really want to be able to say that you have a really good recollection, and where you don't have a good recollection, you have good notes to refresh your recollection or to support your recollection. So I always suggest when an employee first comes to me okay, you need to start taking notes, you need to start recording things, you need to start saving emails. Now, saving emails is tricky. That doesn't always work for everyone, because there might be certain it might be a really private matter that the employee is working on, and these adverse consequences are coming through that one particular file or project. And if you start printing emails, saving them, forwarding them to your own email address, that can violate a number of workplace policies. So you need to really take that into consideration when you're saving emails where you feel like you've been bullied or harassed or those types of things. Like, you need to think about the whole context, not just the fact that you're being harassed in that email. That's why I say take notes, right? So you can say, keep all the private project stuff or confidential project stuff out of it, and take your note and say, on X date, X person sent me X email, and there was a bunch of stuff about the project, or the policy doesn't allow me to save emails or forward them outside of our organization, but this was the context of it. So that's kind of our first advice, is to make sure you have good record. The next thing, if you can, obviously escalate or report as much as you can to really track that as well, right? In Alberta, Occupational Health and Safety Act, as I say, has obligations on the employer to prevent workplace harassment. So to whoever you can escalate to, the better. But in the circumstance where there's nobody to escalate to, nobody to report to, you need to be prepared to leave your job if you want remedy. That ultimately is what it comes down to. Constructive dismissal, which we're going to get into, is the workplace being, in certain circumstances, the workplace being so terrible that you can no longer proceed working there. The problem with constructive dismissal, and the issue that we come up with against all the time, is employees don't realize that to raise constructive dismissal means you need to put the employer on notice that this environment has caused this kind of outcome, and then stop showing up, like stop going to work because you've been constructively dismissed, which means you're treating it as though you've been dismissed from your employment, which means you might not get EI right away. You might have to fight with the Service Canada to get your EI. you probably have to launch a litigation against your former employer for either discrimination, harassment damages, we call them Wallace damages in employment law, and severance. So it takes a lot to, like, from the employee, and a lot of commitment to proceed on what we would ordinarily recommend. If we have an employee coming to us and saying, well, I just can't work there, we're going to tell them, oh, okay, well, then you can't work there. But that means, you've got all these adverse outcomes. You need to fight with Service Canada to get your EI. You need to incur legal fees to launch a suit against your employer. You need to file legal documents. You need to be willing to be cross-examined by the lawyer. All of those things, which is so unfair to somebody who's been harassed in the workplace.
Yeah, I don't know, Sarah, if you remember the case of an employee that was harassed at a Walmart by a fellow. This was probably a little under 10 years ago, and that was a huge situation. But I think that woman had gone through so much, and that's I can't imagine, on top of being harassed, having to do all of that, and then the media's involved, and yeah, like you were saying, it's not fair. Like, I'm glad that it went well in her case, if you're familiar with the case I'm referring to.
Yeah, so and that's the discussion that we have with a lot of our clients is, even that Walmart case, and I've never spoken to the woman, and frankly, I can't recall her name even, and I don't know her lawyer, and I don't know anything besides what was published in the decision. And so we get a decision like that, and it looks really favorably to her, right? And to her circumstance, like, oh, good, they came to the right outcome at the end after all of that harassment and discrimination. The issue is that we don't know, right? Because we don't know her circumstances, what she had to go through just to even get that remedy, right? Let alone all the stuff, all the terrible stuff that happened to her at the workplace. We know because it's in the reported decision. But what we don't know is how did engaging in litigation affect her mental well-being? How did being exposed to the opposing side and having to fight with them for I think it was about 2 years, or maybe even 3. How did that affect her? What were the costs for her legal fees? Did she really end up on top at the end of it, or did Walmart, because they have big pockets, drag her through the mud, and she lost a bunch of money along the way, right? We don't know any of that. It may have turned out that the lawyer was working on pro bono or really great rate, or was very efficient, and she did end up on top. But that's always something that we're talking about with our clients, is not only have you suffered all these terrible effects, but in order to find appropriate remedy, there's further terrible effects. You're going to be crossed by opposing counsel. You're going to incur legal fees. In Canada, we don't have, in the United States, they award really big awards for legal fees to indemnify you for that cost. In Canada, they don't do that. There's public policy reasons for it. We don't need to get into it in this conversation, but you're not going to win at the end of the day and then get all your legal fees covered, which people don't always realize. Like, there's a lot of negatives with respect to litigation and trying to find remedies through the court.
I suppose that's why, because I see this a lot with, just people I've talked to and so forth. When the scapegoat leaves the situation and gets a new job or what have you, it's not like the dynamic has really changed. It's just the scapegoat has. So I would think that it's going to continue even after that scapegoat leaves. And at some point that situation, that employer will be on the hook for the people involved in this, because it's an ongoing pattern of behavior that clearly had nothing to do with the scapegoat. I don't know if that makes sense, but do you see things like that going on?
Yeah, I mean, we often have that kind of conversation with employees. Some employees go, well, I've seen this happen with previous employees, or I talked to the person who used to have my position and they were experiencing similar adverse consequences in the workforce. The people who engage in these types of behaviors, like, unlikely to change and unless they're kind of forced to, or unless somebody brings it to their attention and can really, change the hearts and minds of the people engaging in this behavior. There's certainly instances where people get caught up in kind of herd mentality, right? One person is bullying the person. We are kind of cliquey human beings generally. We're cliquey, right? We want to be part of a group. We want to feel belonging. And so sometimes that can get out of hand and result in bullying, right? Well, I want to belong in the group, and the group dynamic is tormenting this other person, and they just don't take the time to think about it or step back and realize what they're doing, right? And so sometimes, it can be simply a matter of HR getting involved and some people getting their hands slapped and going, oh man, I didn't realize that, right? I didn't realize what my behavior was really doing ultimately at the end of the day. Or people who just, have bad filters or bad, ways of regulating how their behavior is and don't realize that they're offending somebody and they think it's all for fun or something, right? There's the fringe aspects of it. But otherwise, we're looking at patterns of behavior that are going to be repeated against multiple people. And some employees come to us and go, I really want to bring this to the Human Rights Tribunal or bring this to court or hold them accountable, because otherwise it's never going to stop.
Right.
And that's really, inspiring as far as on the outside looking in, but can be really dissatisfying if you don't get the outcome that you're looking for.
Fair enough. And just jumping ahead a little bit, is there ever situations, Sarah, where it's actually beyond the scope of the workplace? And by what I mean by that would be things that are not in a workplace harassment policy, or things that actually are of a criminal nature, such as maybe an employee or an employer stalking another employee or extorting them for money, or say a waitress being denied help from her employer, but she's being stalked and harassed by a patron on a regular basis and is concerned for her safety. Are there ever incidents like that go beyond a workplace harassment type situation?
Yeah, so when you first asked about beyond workplace, where my mind went was online, right? You become friends with your coworkers online. You may or may not want them on your social media. You feel pressured to put them on your social media or grant them access to your social media. Then they, start infiltrating your private life on social media. So all of these behaviors that they're already doing at the workforce or at the workplace are now extending beyond that. That's becoming very common. The extortion, less so. That's pretty a pretty obtuse thing, right? Extortion. Obviously it occurs, but it's definitely on the rarer side of things. Really what we see is power dynamics playing out in the workforce and then extending into your private life. So and that can include the stalking that you've described, right? For in really extreme situations, you get somebody who initially you think is, oh, they're my coworker or my boss or my colleague, so I'm going to engage with them on some level, and then the relationship turns toxic, and that person now knows, because of your good faith engagement with them, in prior months, that, oh, I know where you live. I can pop by, with, whether my intentions are nefarious or not. It's a power dynamic. I know where you live. I can show up at your house. I can do those types of things to intimidate you. Even if when they stop by, they're like, oh, I'm just here to drop something off, or I'm just here to follow up on that project, or you promised me that you would bring in a copy of X agreement, so I showed up unannounced to pick it up now. Those things can seem very, kind of innocent almost, unless you know that there's this power dynamic going on. And texting is a big one, right? We have Teams, we have Zoom, we have email, we have text, we have phone, everything, especially working from home, everything is forwarded to your personal cell. That can be really inundating and go outside, where do our work hours end, right? And in COVID land, for most of us, they never end, right? We're kind of always now working. We're always engaged in our work environments. So it can definitely go beyond work, and that can be informative as to whether or not the matter kind of hits that level of constructive dismissal. But it's not under Occupational Health and Safety Act, for example, in Alberta, it's not clear that behaviors by employees outside of work hours, for example, even a union meeting, there was a case in Alberta about a union meeting and whether or not that employer was responsible for what was happening at the union meeting. And so that's where it kind of like gets into this gray zone where it can inform whether or not there's constructive dismissal because it is what you're experiencing with your coworkers. But it might not lead to the employer otherwise really being very liable for things.
Interesting. Thank you so much. That was a fantastic explanation. And I guess to branch off of that, I know for myself, so I don't use social media outside of what we're doing. I don't have Facebook, Instagram, Twitter, etc. So I try to, as much as I possibly can, separate myself from work friendships outside of work. But so on that note, are there things that you can suggest, some tips maybe for employees to, you can't really prevent or stop the people that you work with who might have character issues or toxic behaviors, but are there things on the employees' end that they can try and do to mitigate as much as possible any of this potential stuff going on?
Yeah, so one is trying to reflect on when the behaviors seem worse or the worst, right? So for some people, they have a really hard time being aggressive or bullying in person, but they, don't hold back on those behaviors at all in writing. So in those cases, using the phone, calling them up, being, engaging in some of those more direct methods of communication might actually stem the flow of that kind of behavior. On the reverse, some behaviors are not really put into writing because they're aware that it's going to be in writing, and so they really only do it in person. Now, some do both, right? But let's say you're one or the other. I always suggest try and reflect and see where is this coming from and where does it seem to be the worst, right? And then trying to take control of the narrative to some extent and switching your engagement with that person to where it seems better rather than worse. If they're of the type that engage equally, both in person and through phone and more direct methods of communication and through writing, then just try and switch it all to writing, because at least then you've got it in writing and you can refer to it. It also sometimes can be a lot more of a safer way to engage with people who are going to not only harass you, but get to the ends of that, which is, moving into violence. Keeping it in writing, at least you have a record of that. So that's maybe one coping mechanism. We started this by talking about social media. I used to be, prior to going through law school, I had a different career, and I never would allow people on my social media. It was just a thing that I didn't do. And there was coworkers that I really liked and coworkers that, I could take or leave, but I just, I had a broad policy that you weren't my friend on social media if you're my coworker. Now that might not work for some people. Like some people love having coworkers that they're friends with and that they socialize with and what have you. I had the type of job that I was happy to see my, the coworkers I liked during my hours of work and then, had practically very little to do with them outside. And not because they were bad people or because they were harassing me or anything of that nature, but it was just my way of engaging in the workforce. That can help if we're talking about people who are using these connections as a way of exercising power. it seems to be easier to enforce a blanket policy to just say, I don't have anybody on my social media from work, than trying to pick and choose, because those people often say, well, how come I'm not on your social media? And they try and, kind of bully their way, the way they bully their way through everything, into your social media life. Otherwise, obviously there are ways, if you're on social media, to create kind of bubbles, right? We've got on Instagram the close friends option when you're sharing a story. Facebook, you can kind of group people into different groups so they can't see what you're posting, those types of things. So there are ways to kind of use the technology to your advantage to a certain extent, or hiding your story on Instagram from all your coworkers, right? You can just go through and add them all to a list that says, well, they don't get to see my stories, those types of things. So they still look like they're your friends online, and they can't really bully you about not being friends, but then they don't see things, and that means you're not front of mind for them when they're on social media, and that you're not getting targeted as much. Those are some ways to deal with it, I guess, but again, it's always difficult when you're dealing with somebody with these kind of toxic behaviors.
Yeah, definitely. And that actually brings me to something, Sarah, that I really wanted to ask you, because this is common in my experience from what I've heard from some of my coaching clients and things. But it's super hard to prove, as I'm sure you can imagine, where the toxic, like the bully, the big harasser in the workplace will, in front of other people, act like you get along very well and they have nice things to say about you, but when nobody is looking, they're harassing you in a corner and saying very derogatory, demeaning, even threatening types of things, so that, if you were to report it, nobody would believe you, that type of thing. Is that something that people should still be documenting and recording, even if there is no witnesses? It's like, I'm not sure how you can prove things like that.
Yeah, I mean, proof is a very difficult thing. A lot of this harassing behavior, and the courts have identified this as it can be very subjective, right? I interpret it as harassing, the harasser interprets it as reasonable management decisions. The people around you interpret it as, all in good fun, or they're good behavior because they haven't seen, kind of the hidden corners of that, the skeletons in the closet. So proof is definitely difficult. I still think it's always a good idea to take notes about what's happened and when. Again, memory is fallible. If anything does need to be brought to light, either in the courts or in a tribunal or something like that, or even just in negotiations with an employer regarding severance or some sort of payout, though that can really show to an employer, like, look, I've been taking notes for the past 6 months. Like, what more do you want from me? Past year, whatever it is, right? So it can be helpful. Now, with respect to recording, as in recording an audio of that kind of behavior, I usually do not recommend that. There's a lot of dispute at the court level about whether or not that's appropriate behavior by anybody to record without others knowing. It's one thing to say, I know you're recording me right now, right? Like, that's obvious. We're both engaged in that. It's another thing. The courts have they're split on whether or not they look very favorably on people recording conversations that, kind of secretly. So if I was at the workplace and I think I'm having an open conversation with somebody, and really what's happening is they're recording me, the court can really backfire on you in that case and say, like, that was totally inappropriate, and this was obviously, a two-way toxicity, because you're trying to record them without telling them, and et cetera, et cetera. So I hesitate to recommend it, because it can be very tempting to say, well, there's no other way for me to prove this. The other thing that people should know is that whenever you're in litigation, you have to disclose everything that is relevant. That means every recording. And if you lost your cool and it doesn't play very well for you, you got to disclose that recording if you're in litigation. And that also means that there's no way to suppress or to say, not to disclose that, which means that even if it went really, in your favor and shows your point in the recording, you're still going to have to disclose it. And it's certainly going to be something that the opposing side brings up to say, why were you recording people without telling them? And the court, may look unfavorably against it. Now, it might be fine. As I say, the courts are split on it, but certainly something you want to keep in mind before you start recording people. And I usually recommend against it.
Yeah, that's really good advice. And same with your advice about when forwarding emails and so forth to your private accounts, that may actually be against the company policy, because it would be tempting, to, I want to make sure I have a record of this, and that's something that I, wouldn't have considered. So thank you for that. Thanks for that tidbit, because that's great. Very helpful.
Yeah, we find that lots of people, they start printing things or forwarding things, and then suddenly they're getting, either disciplined or terminated at work for breaching a policy. Well, because they were already looking for a reason to get rid of this person, and that's, they've been bullying them and trying to push them out in some way. And then they have, well, you breached this policy, and last week you signed off on it and said you understood it, right? Which everybody does, right? People often sign off on policies without thinking about how they actually apply. And sometimes you don't even need to sign off on the policy. It's just communicated to you in some way, and then, you're held accountable for it. So it's definitely something to keep in mind. And even if there isn't a written policy, like if there's been some sort of communication, even verbally, to say you can't forward emails, or you can't, this is supposed to be confidential, or even generally just trade secrets. So there's no policy, but this is clearly a trade secret somewhere in that email thread. You really don't want to be putting that outside of the organization.
Yeah, that's fair enough. That's a really, really good point that you made. Sarah, I think like in these situations, like you're mentioning about, the target losing their cool and things like that, I always find it really helpful that a person in that situation would seek some sort of outside counseling to prevent those types of things from happening, that they're being validated, that this is real, and so that they're not finding themselves in those traps that are actually giving the abusive people more ammunition against them, right? Do you find, even if say like an employee is experiencing this, but they don't have money to hire a lawyer, is it even worth their while to say, like, find somebody that can do a brief 20-minute consultation, or, just things like that can help them a little bit?
Yeah. So, I mean, for lawyers in Alberta, like most of us are really costly. Like we know that, we recognize that. There are a few ways to get at least, some legal advice or some legal information. One is to see if there's a pro bono clinic in your area, or like a 1-800 type number for a pro bono clinic. So in Calgary, we have Calgary Legal Guidance. They do great pro bono work, and they will have lawyers available to kind of give employment information and advice. Those are usually at Calgary Legal Guidance, usually about 30 minutes. But you do need to financially qualify for their services. So that means if you can fall into that range where you're outside of a pro bono clinic financial guidelines for what they will do to help somebody, but you're not quite making actually enough money to comfortably pay a lawyer. Or maybe, you're in a situation where you have to help a loved one or something like that who lost their job, right? So yeah, your income looks okay, but it's not really okay at the end of the day to be incurring a bunch of costs. So then the alternative would be to try and find a lawyer who can talk to you for, a 30-minute or a limited retainer. I sometimes do those. And I know others in the city do those, where it's okay, we're entering into a limited retainer to give you limited legal advice. You've retained me to work for 4 hours, right? So at the end of the 4 hours, that's all I can give you. And then you're on your own, right? Because that's all you can afford. That can sometimes be possible. It's difficult to do not difficult, but it can be challenging to do limited retainers because we have an obligation to make sure that the client is fully informed. You know, the Law Society has certain obligations on us. Our professional insurers have certain obligations on us to make sure that we're, you know, crossing our T's, dotting our I's, providing sound legal advice. Sometimes that can't be done on a limited retainer. So it really depends on what you need, what you're looking for, whether or not we think that you can understand the concept of a limited retainer, even those types of things. The other option is to ask for referrals. You know, so at my firm, we have a certain hourly rate. We don't discount our rates. We don't really do, we have some contingency on personal injury, but like we don't do employment contingency fees, for example, that kind of thing. But you know, we might know people in the city who might be able to work on that, and the lawyers across Canada, when you work in a particular area, we all know people. It's a small community of sorts, and so referrals can be an option. There's also groups like Legal Aid, although they don't often do employment issues, but in some provinces they might. In Alberta, it's very unlikely that you would get coverage through Legal Aid, or the universities, the faculties of law at the universities often have pro bono clinics. When you introduced me, you mentioned Pro Bono Students Canada and Student Legal Assistance, the two organizations I spent my time with in school. I would have been able to take on clients through those programs. Now, we don't take everybody. Their students have limited resources. They have, you know, limited capacity on what they already know, what they can really comfortably take on without doing a disservice to the client. But that can be, you know, a resource. And then, yeah, like a lot of law firms do at least 30 minutes of free legal information. We can't give advice in those 30 minutes, but we can give legal information, which means we can lay out some of the legal tests. We can't tell you whether or not what we think, do you fall within this test, but we can at least say, you know, here's the case law from the Supreme Court of Canada. It lays out the test for discrimination as, do you have a protected characteristic? Did you suffer an adverse effect? And was that adverse effect tied to your protected characteristic? Right? And then you might say, what's a protected characteristic? And I'd say, oh, it's enumerated in the human rights legislation in each province, and there's also a federal one. So, you know, I can refer you to the legislation, and then you can do some reading on your own, kind of going from there. The human rights tribunals also throughout Canada are really designed to be self-represented, or maybe not designed for that purpose, but are designed to help people who are self-represented get through the system. So that's really encouraging for people who can't afford legal representation, that often they can represent themselves. And the lower levels of court are also often self-represented individuals. So in Alberta, we have provincial court, which does damages up to $50,000. And then we have Court of Queen's Bench, which is our superior court. It kind of changes throughout the provinces what those two are, but essentially there's a provincial court and a superior court in each province, and then a court of appeal. So that lowest level of court in Alberta, it's the Alberta Provincial Court. That one, often people are self-represented for, and in Alberta, there's a lot of self-represented litigants at that level. So if you're looking at $50,000 or less worth of damages, you can go into that court and fill out the forms, get assistance from the court clerks. The courthouse used to be a really great resource. They have pro bono clinics running out of the courthouse in Alberta, in Calgary and Edmonton anyways. And court clerks, you know, they do the paperwork stuff all day long, so they can at least help you on kind of some of that administrative stuff. Fortunately, with COVID, that resource is kind of limited now. It's not as easy to get into the courthouse, even frankly, let alone access those kind of resources, but they're still there in a limited way.
Fantastic. Thank you so much for that amazing information. And Sarah, just before I let you go, on that note, in Ontario, anyhow, I'm not sure if this is the case in Alberta, but I believe in Ontario, there's paralegals as well that will work for law firms in this, and then they can offer some advice or some help at a reduced rate. Do you have that in Alberta as well? Is that something that
So no, we don't really have that in Alberta. That's a
Okay.
very unique thing to, I don't know if it's only Ontario. Ontario is, from my perspective, the most well known for it. But in Ontario, paralegals are really regulated and have their own professional organization and all of that. And you can qualify to a certain extent to give some of that limited legal advice. And because I don't practice in Ontario, I'm not sure what paralegals look like, or where the line is, like what they can do, what you need to get a lawyer involved to do, if there's even a line. I'm not familiar with the paralegal system in Ontario, but that's not really something we have in Alberta. Now we do have you know, provincial court and traffic court, for example. Like you can have all sorts of kind of oddball legal representation of sorts, I suppose. But Alberta is much less flexible about it than Ontario is. So certainly something to look into if you're in a, you know, in a province that has those kind of options. Alberta we're very insulated with our lawyering, I guess, our legal representation. We do not have a lot of flexibility with respect to who can really represent you in court in that way, or represent yourself to other parties. Now, of course, anybody can write a letter on your behalf or something like that, I suppose, but to really engage with the legal system is a little bit more challenging in Alberta if you're not called to the bar.
That's great to know. And Sarah, thank you so much for your time tonight. This has been amazing. Like I've learned so much, and I know a lot of people are going to benefit from watching this. And I really, really appreciate that you took the time to do this. Thank you.
Absolutely. So happy to be able to come on and talk to you, Tegan. It was really, really fun for me as well. And I hope that it helps a lot of people to get this information out there.
Absolutely. It was a real pleasure to talk to you this evening. It was an honor to have you. And thank you so much again for everything that you're doing.
Absolutely. Have a good night, Tegan.
You too. Thanks, Sarah. Bye-bye.
Bye.